Major Supreme Court ruling on Friday in Fisher versus United States, finding that the obstruction of official proceeding charge that was used to prosecute many of the January 6th insurrectionists is inapplicable as it relates to many of those January 6th insurrectionists, potentially hundreds of January 6th insurrectionists who were charged with that count, obstruction of official proceeding, may have that charge dismissed. There may have to go through new trials and may have to be repled based on what the majority decision says about connecting it to documents and objects and a very, let's say, interesting or perhaps tortured statutory analysis here where the plain meaning of 18 U.S.C. section 1512 sub C2 seems to be clear that it's otherwise obstructing any official proceeding, and the January 6th certification was an official proceeding. But anyway, I'm here to break this down in more detail with Mike Sachs, senior advisor from Court Accountability and correspondent here on the MeidasTouch network. Mike, it's an interesting 6-3. Ketanji Brown Jackson actually joined the majority and issued an interesting concurrence. Amy Coney Barrett in the dissent. Before going to those nuances, though, how big is this? Was this unexpected? What are your thoughts on it?
This is big, but was expected. When the Supreme Court granted the certiorari in this case, the writing was pretty much on the wall that this court was going to very narrowly read this obstruction of official proceeding statute from that 300-some January 6th defendants were charged with in a way that it would throw out those convictions of those defendants. Now, mind you, that former President Trump was also charged. Two of his charges in the January 6th case that's been on hold due to the immunity case that the Supreme Court still hasn't decided. Two of those charges that Jack Smith brought against Trump were also implicated in this decision. But ultimately, the Supreme Court, 6 justices, 5 of the Republican supermajority, and Justice Ketanji Brown Jackson, which we'll get into in a moment, why she voted this way, gave a very narrow reading to this law, which was passed in the wake of the Enron scandal, to say that Congress did not really intend for this law to apply to a riot, an insurrection, a deadly one at that, at the Capitol to obstruct the Electoral College proceedings and validation, which frankly is an official proceeding. It is. But this Supreme Court said no. And the 5 justices in the majority gave this very exceedingly narrow decision. And they typically don't tend to like criminal defendants, except when they're public officials accepting bribes and being corrupt, when they're cool with it. Or now, if you're January 6th defendant. The 3 justices in the dissent were Justice Sotomayor and Elena Kagan. Writing for the 2 of them, though, was a 3rd, Justice Amy Coney Barrett. When we get into the specifics of why each one did these things, this is important to understand this court, because we should know who they are and what they stand for just as much as we should know that about our politicians, because these justices are part of our political system. They are, if you want to call them that, politicians as well. The reason Justice Ketanji Brown Jackson sided with the 5 male Republican appointees wasn't because she wanted the January 6th defendants to go free. She had no interest in that. She says that at the very top of her concurrence. But she was a former public defender. And she is very solicitous of criminal defendants' rights, probably the strongest on the court so far, even in her 1 year on the court in doing so. So she was going to always give, and she indicated this at oral argument, that she was interested in giving a very narrow reading to this federal criminal law so it doesn't sweep more broadly than it should. But in her concurrence, she also said that does not mean that the January 6th defendants were not guilty of violating the statute. But prosecutors, you got to go back and retry them, but look for whether they did mess with documents, whether they did, tamper with the Electoral College counts, tangibly so, instead of use a more abstract understanding of this law. That's where she came down. She says, no, January 6th defendants, you are not off the hook, but you will get a fairer pass from the prosecutors. Because Ketanji Brown Jackson, I'm pretty cool with criminal defendants, no matter what you did, even if it goes to destroy our democracy. In the dissent, Barrett, who wrote for the dissenters, the other two Democrats. Barrett, for her, it was a matter of text. She is a Scalian textualist. What the text says goes. It doesn't matter if the Congress did not foresee this particular text to apply to this particular issue. If the text itself does, by its plain reading, apply to what the January 6th insurrectionists did, then so be it. And that was her reading. And that's where she departed with some of the other so-called Scalian textualists in the majority, who wanted to give it a very cramped reading. You've seen these things before. There's the Bostock case a couple of years ago, reading sexual orientation and gender identity discrimination into the workplace Title VII rules that forbid discrimination on the basis of sex, saying that discrimination on the basis of sexual orientation or transgender status counts as discrimination on the basis of sex. And you had a division between Justice Neil Gorsuch, who sided with the liberals in that case, along with Chief Justice Roberts, saying doesn't matter what the people in the 1960s meant or the 70s meant when they passed Title VII. They weren't even thinking about gay and lesbian people or transgender people. Doesn't matter. Sex, discrimination based on sex means sexual orientation, gender identity as well, the way it should be read by its plain text. And you have the dissenters saying, no, that's not what Scalia meant, and that's not bitextualism, that's not what we're going to subscribe by. Interestingly enough, though, you have Justice Gorsuch and Chief Justice Roberts, who are more readily reading broadly Title VII in that case, to give it a very cramped reading. Give the federal obstruction statute a very cramped reading in this one, to let the January 6th defendants get a retrial, if not go free. And Justice Amy Coney Barrett, in her dissent on behalf of the two liberals who did not join the majority, she said that the plain text of this statute very much does apply to these defendants. And she used the word backflips. She pretty much said, and I can read a quote here. Let me just pull it up for a moment. So I have it. She says that that the majority was doing backflips to achieve its result today. And that's where we stand with the January 6th defendants, and also former President Trump. And we'll know soon enough also about whether this court is going to let him fully go scot-free from his January 6th insurrection criminal trial altogether.
Right, and they have not reached their decision yet on his claim that he can order SEAL Team 6 to massacre anybody he wants and get away with it because he should get absolute immunity and you can do whatever you want to do. There's an interesting one though, right? Because Trump was charged though here too with the 2 obstruction of official proceeding counts. And so there's a debate going on right now whether this order would result in those charges being dismissed as against Trump or not. A lot of the constitutional scholars, Supreme Court scholars, legal scholars, who I've been talking to say, look, I don't think it's a foregone conclusion and that those charges get dismissed. In fact, if you read the language, there is even possible, it was written with an eye towards, assuming that there's not absolute presidential immunity, though, that Trump's conduct could still fall within the ambit of 1512C2. I'd love to know what you think about that. But here's how Justice Roberts concludes the order, saying what he believes 1512C2 means. To prove a violation of Section 1512C2, the government must establish that the defendant impaired the availability or integrity for use in an official proceeding of records, documents, objects, or as we earlier explained, other things used in the proceeding or attempted to do so. Now, for a lot of January 6th insurrectionists who engaged in violent and despicable conduct on January 6th, their design was not necessarily document focused or even so much focused on the integrity of the proceeding, but Trump's clearly was. I mean, whether it was the fake electors, whether it was trying to stop the real authentic documents being used. I don't know if it has to be repled in light of this and there has to be a superseding indictment, or if you think it's good as is. What do you think?
I have no idea. And the superseding issue involved here is whether this trial is even going to happen. Because remember, he, as a delay tactic, former President Trump, said that he cannot, whatever the indictment, whether these 2 stand or don't, the 2 remaining still exist, whether he can be criminally charged for criming while in office, allegedly so. And that's what the Supreme Court's been sitting on and waiting and holding till the last day of its session to decide. And it indicated pretty clearly that it wants the lower courts to figure out what was an official and what was an unofficial act. Official acts would get immunity and the unofficial ones wouldn't, or maybe only a subset of official acts get immunity. Who knows? But the Supreme Court's own delays at every turn in this immunity case has ensured, all but virtually ensured, that the trial before Judge Chutkan in the DC District Court will not proceed and conclude until after the election. And that's the ballgame for the former president. That's the ballgame. That's all he's ever wanted. That's all everyone's known this immunity argument's been about. So whether or not it has the obstruction charges have to be repled, or whether they be dropped, or whether they do fall within the ambit and are still kosher under the majority's decision in the Fisher case, remains to be seen. But we do know, what we have seen, without even seeing a decision from the court, is that its delays have all but ensured that the American public, when they go to the polls this fall, will not have the verdict of a jury of the former president's peers in DC, whether or not he is guilty of trying to overturn the 2020 election. And the Supreme Court has ensured that. The Supreme Court has given pretty much an in-kind donation to the former president's campaign in depriving the American public of that information. And it's this thing is what I think is one of the most tragic things about this court's current term, among many other things and the decisions we've already seen. This one shows a clear political interference in a way that we haven't seen, of course, since Bush versus Gore.
Well, they may be inconsistent, putting it lightly, with precedent, but they sure are consistent when it comes to corruption and ripping apart the norms and traditions and things that underlie our democracy. But we're going to keep breaking this down together. I think there's almost no issue more important than talking about the inner workings of the court and how it's impacting our lives. It's about time a media network actually confronts it in detail, not with sound bites. That's what we're doing here. Mike Sachs will be leading the charge there, or leading the charge here at the MeidasTouch Network. Over there, meaning at Court Accountability, he's one of the people leading the charge as a senior advisor there. And thanks for joining us on the MeidasTouch Network and being a correspondent here and helping our coverage. We really appreciate it.
Thanks, Ben.
Hit subscribe. We're on our way to 3 million subscribers thanks to your support. Thanks for watching and have a good day.
Real quick, Meta just changed their algorithm to suppress political content. Please follow our Instagram at MeidasTouch right now as we head towards 400,000 followers so you don't miss a beat.